Thank you, Chairman Langford, and thanks for calling this hearing. As a former state official myself, I completely understand and appreciate, having worked with my legislature and having served in state government, the challenges that we face every day when we have two regulatory regimes and trying to make those balance and understand the impacts. And so, as I've said before, it's critical that we examine this kind of legislation. It's critical that we look at what's worked and what hasn't worked, and so I'm grateful for this hearing. But we can't lose sight that regulations are a critical part of how the federal government keeps our products safe and our food safe, as well as ensuring a level playing field for our businesses. To get good regulation, we need a strong regulatory process. And part of that strong regulatory process is engaging stakeholders early. As Senator Langford and I know, we look at these regulations and we say we need the regulators to talk earlier with industry, labor groups, and other stakeholders when they're developing the rules, rather than doing this in a vacuum and then presenting the rule as a completed effort with no real opportunity for comment. So I believe strongly that consultation with state and local and tribal governments is part of the needed outreach that's critical to this regulatory process. Congress should always consider the compliance costs of legislation and how states, local, and tribal governments will be impacted. Appropriate consideration must always be given to how decisions are made in Washington and how those decisions affect the bottom line back home. This analysis and consultation means we can create a safer and more equitable nation without unneeded regulation, but with the right amount of necessary regulation. And so out of this need and out of this discussion, Congress passed in 1995 the Unfunded Mandates Reform Act. This law has worked to keep us and the executive agencies accountable in their home states and in our communities. It's helped ensure that those of us on the Hill understand how our actions affect budgets beyond our own. It requires agencies to consult with those individuals who have boots on the ground and know how those rules could be followed and what works and what doesn't. It's important then, as we approach the 21st anniversary of President Clinton signing this bill into law, that we take a step back and review this important legislation, a retrospective review, if you will, that we check in our states and local, that our states and local partners believe that we are doing the right thing in terms of making sure that they have an opportunity to participate and have an opportunity to weigh in terms of those additional costs. And so I look forward to hearing from these witnesses today. I look forward to continuing this dialogue in this committee with Senator Langford and with all of the members of the committee who have worked so hard to try and achieve bipartisan solutions to maybe some of the more contentious issues that we have in Congress. And so I welcome the Honorable Congresswoman and look forward to her testimony. Thanks to all the panel, just very reasoned and measured responses, and I think a great opportunity to have a dialogue with all of us here. And I don't mean to hijack this from the topic, but since I have someone from the counties and someone from the state legislature, I want to talk about an issue that I think is also critical, and maybe, Professor Posner, it goes to an additional issue that we could include in an intergovernmental aspect. Frequently, Senator Langford and I opened up a portal which said cut red tape. I always want to say the red tape. Cut red tape. And we invited criticism and, tell us what's working, what isn't working. A lot of criticism that we got was of state regulation. It was of local regulation. It was about duplication between federal regulation and state and local regulation. And that adds to the burden, it adds to the confusion, and it certainly adds to the costs of achieving a public purpose that we're all trying to move towards. Now, this is a situation where a fair application of the 10th Amendment, you can say, well, if the states are regulating, federal government ought to think twice about whether they ought to do it. I'm a big 10th Amendment person. I hate preemption, and because I think these are the laboratories of democracy, which are state governments. And so when you were talking, Commissioner, about the regulation, a lot of what you talked about on consultation involved not federal mandates, but mandates coming from state legislatures and from executive agencies. My question is really to the senator. Do you know of any model legislation that states have adopted on unfunded mandates that deal with just state regulation and pushback from counties and cities, from townships, from local government, that really can help us inform a model beyond the model that we're working with here?
Thank you for the question. One of the challenges with the...
Turn your microphone on.
There we go. Thank you for the question. One of the challenges with the premise of the question, there's a different relationship between the federal government and the states than there is between state governments and the political subdivisions within the state. The vast majority of states, there's a few states that have a home rule difference, but the vast majority of the states, the political subdivisions, the cities, the counties, the towns, school districts, all of the special service districts, et cetera, derive their sole authority from state statute. And so the comparison saying, well, doesn't the same problem exist in the states where if the state legislature tells its political subdivisions what they should do and they don't provide funding, isn't that analogous to the federal government? Well, Madison in Federalist 45 had something to say about that. He, talking about the proposed Constitution, he said the powers delegated by the proposed Constitution to the federal government are few and defined. Those which remain in the state governments are numerous and indefinite. And so when a state legislature sets policies within the state, the difference between that, there are some comparisons. One size doesn't always fit all at the state level, and that's a challenge. When you have a state like mine, the state of Utah, we have mountains, we have desert, we have very different climates.
I get all that, and I do truly understand the 10th Amendment and the 11th Amendment. But my point is, and it's not to say we don't have an obligation here to look and see what the federal-state relationship ought to be. But as I've pointed out frequently, and I think if I were a county commissioner who had my limitations on my property taxes restricted by state legislature only to receive a mandate on my share of the Medicaid expenditure, I might take issue with that relationship. I see my commissioner laughing a little bit. And I don't mean to cause a fight between local and state government, but I have been in state government long enough to know that that tension exists. What I'm trying to get at is you know, we look very closely at what other models there might be, whether they're international or whether they're, you know, within our system itself, on how we could do a better job coordinating between all the levels and all the branches of government. And so for me, this issue is bigger than just federal unfunded mandates. It's how do we work together on a layered basis to actually achieve results. And I want to go to waters of the United States. We've been litigating waters of the United States for, what, 30 years? We've been arguing about what is jurisdictional waters under EPA. It's time that Congress do its job and legislate what waters are, to create the lane. Because without Congress legislating, they're going to be wandering around out there in my wetlands, in my potholes for the rest of my life. And so, you know, we can deal with the stay that we have now. I have legislation. I know it's been endorsed by both the organizations. Really appreciate the support. But I want to get to Professor Posner, right? Yeah. Idea about some kind of more institutional framework for dialogue and consultation, because I agree with you. I do not believe there's enough consultation on the front end. Well, I think that's true not only for state and local governments, we believe it's true for stakeholders as well. And so we have a bill headed up by Senator Langford to require additional, you know, notice before rulemaking begins so that we can get comments earlier. I begged EPA to reissue the rule, Waters of the United States. They said they did enough consultation. I don't agree. Don't think the courts of the United States agreed either. And so here we are, once again, creating this great uncertainty when maybe that could have been avoided with an institution that was greater dialogue on the front end. And we aren't here to litigate individual legislation. We're here to talk about how we can structure the relationship in such a way that it actually gets rid of the conflict and achieves the result. And so I know if I talk to my colleagues about creating yet another intergovernmental agency or another agency, the groans will come up. You heard it, right? You heard the groan. But you know, I'm curious how you react to the groan and what persuasive argument you can make for your idea.
You look at all the major federal systems in the world and the advanced in the OECD, we're the only ones without a real extensive consultation mechanism. Germany, Australia, Canada have very extensive consultations that work out
And
a
very
lot of these
robust
problems.
subnational involvement.
Well, exactly, and staff, they staff it too, so it's not just an honorific kind of initiative. I think these kind of things obviously take a lot of work, but I think one of the things that happens sometimes in our system that you alluded to, is we focus on these different titles, Title I, Title II of UMRA. Really, Congress sometimes Congress sets up the agencies to have difficult problems because they don't really legislate.
Right.
You know, I think about the Real ID Act of 2005, where, you know, basically the state motor vehicle administrators have worked a bill that Congress approved that was going to use regulatory negotiation with the Department of Transportation to work out a national ID, not called a national driver's license that was hardened. And then Congress, literally 3 or 4 months after that, imposes a Real ID with much more stringent requirements and no consultation at all with the state and local community, and transfers it to DHS, and then they wonder why it's taken 10 years to implement it with all the state pushback. So I think, you know, a lot of this consultation, if we had done something before Congress even approached that through some kind of intergovernmental process, I think we might have been better off in the long run. That's the idea.
So, Professor Pierce, you said one of the things that you're concerned about is we aren't currently meeting deadlines in terms of regulation. I can give a concrete example where failure to regulate actually had tremendous costs, and that's in the tank car regulation that DOT just did. They waited too long. The industry went ahead and built a new generation of tank cars. All of those tank cars that are, you know, just rolled off the factory line now have to be retrofitted to meet the guidelines. I'm not saying that was the wrong answer. I'm just saying failure to engage and regulate actually costs money. So we need to remember that this is, that regulation many times can be clarifying for industry and can achieve a result. So what's your response to a commission that would be charged with managing this relationship?
Let me just start by expressing my complete agreement with you and with Professor Posner that I think this is the core problem. And it's just difficult, really difficult for a lot of reasons. First, the substantive issues we're addressing here divide everyone. The Supreme Court, Waters of the United States, I teach that case every year. The Supreme Court divided 4-1-4. There were not 5 justices in support of anything. There were 2 justices, each of whom was on different sides, the Chief Justice and Justice Breyer, who said, you've got to make a rule. Get together and make a rule. Get a rule together and we'll support it. Well, I wasn't sure I believed them when they said that, but a decade later we have a rule, and predictably no one likes it. There's tremendous... when you try to get 50 states to agree today on anything important, that isn't going to happen. Right now, in the context of climate change, you know, the initial judicial action in the Supreme Court was instigated by a state, and now the reaction is 8 other states oppose. So
I think people forget
nothing
that.
is going to produce agreement among the states.
So don't you think, that, let's go back to the question, which is the institutional, you know, kind of finding some kind of institutional place for this dialogue. Do you believe that that would assist in at least getting early indication of those conflicts?
I don't know, because the next problem is each state has its own unique governmental structure, and I've tried to help federal agencies who in good faith have tried to go out in consultation, and they've discovered not only do the states differ with one another, they differ within. And one state institution, the governor's office, will say, our position is X, and another state institution says, we're the ones who control this, and our position is Y and not X. So trying to figure out with whom you consult, and then the result, when you wind up tallying votes after a lengthy consultation process and conclude that 23 states are on one side, 23 states are on the other.
Now you're just depressing me.
And the others disagree internally
I-
on what should be done. I do not have an answer to the problem. I agree completely that's the problem.
Thank you.
Could I just maybe turn one light bulb on, as dim as it is? There have been some examples. The insurance, the federal government was threatening to take over the property casualty insurance business from the states under Graham Leach Bliley, and that prompted the states to get together and do their own voluntary codes, which significantly helped, at least in some people's mind, the state of play in the states. The other one that you're very familiar with is a simplified sales tax initiative, which 25 states bought into, which has been a real help. Now, you're right, it's not all of them. We have some significant states that are outliers, but that provides a foundation, and they said it couldn't be done. Each state had their own
We can go
definition
back
of
to the
that.
Uniform Commercial Code, right? I mean, which is a great example of state cooperation to avoid a federal commercial code, you know. So I appreciate and understand, having come from state government, having refereed these dialogues as the Attorney General, but I'm looking for systematic reforms that, number one, we can sell to our colleagues, because our really good ideas are having a hard time, right, James?
So they are really good ideas.
Really good idea. We really like our ideas, and they're having a hard time, and so we need to be as persuasive as what we can and get consensus on our ideas.